Hi, so we are just going to pick up from the introduction last week and build upon our knowledge of registered land, knowing that we've another week of looking at registered land together also. So just before the lecture starts, just want to apologise to students who I couldn't attend face-to-face sessions with in Cambridge. I had a severe allergic reaction at the train station, and luckily I had my EpiPen with me, but I yeah, was struggling to breathe, airways and everything congested. Still am a little bit bunged up and eyes are streaming, so if I need to clear my airways at any stage, I do apologise, but I will do my best. So we're looking at registered land as a system, a way for people to be able to articulate that they have a hold over the land in some way because they have a right or interest that affixes or attaches to the land itself. So what we're going to do in this session is to build on that work that we looked at in the last lecture of, the fact that we have a lot of land legislation coming in 1925, updated in 2002, and we've already looked at some of those objectives, the idea of the mirror principle, the insurance principle, the curtain principle, and the ideals behind why it's a good idea for people to be able to say that they have an estate or interest, and a way then for us to verify that by having a register that people can go to and protect themselves by their entry upon it. A new purchaser or a lender can also go to the land registry and then verify the existence of that right or attachment. So we're going to look at that in a little bit more detail as a system, and we'll look at how that comes about and what it looks like. I'll then start to introduce you to how some of these people might then protect themselves and articulate their statutory protection mechanisms. So how do they protect themselves using the Land Registration Act 2002? What is it that they have, and how does the 2002 Act recognise that and put a system in place for their protection? Please don't worry about the last few slides where we start to do that, because we have another week to work through that together. We have another week of land registration and affixing and attaching people to the land using it. So for the last few slides, I'm starting to introduce this system to you and these ways that people can be recognised by the world at large once they've been to land registry. But for now, just use this as an opportunity to carry on building upon that foundation that we already have started so well in observing estates and interests, law and equity, the paperwork required, and then articulating at land registry how they would be protected. The purposes of all this being obviously that prior to 1925 and the gamut of legislation that came in that year, we were subjected to people who may have had some form of hold over the land, but it was very difficult to articulate or identify what that was, who they were, where they were even at times. And we could have situations where people would come back after a period of absence or travel or hospitalisation, expecting still to have some form of hold over the land. So the registration system is a way to avoid that. The registration system provides these people with an opportunity to enter their hold over the land in a state registered, transparent way, and then for purchasers or lenders to be able to go to the register also and see that that person exists and take the property with that knowledge. So for our purposes, we will see the register as a whole, but it is broken down in three sections. So there are three distinctive parts of the register. we'll have the first part being the property register, so identifying the land itself, literally an address of the property and what benefits might come with that property. The proprietorship element then will articulate and identify who would be the fee simple absolute and possession holder or holders of the land. So the people that we would recognise as owners or freeholders, we will see as the fee simple absolute and possession holder on the proprietorship aspect of the register. And then thirdly, the charges register. The language usage there is quite important, because if you picked up in the previous lecture, the Land Charges Act, that was a way for people in unregistered land to enter a charge to protect themselves, because they had a right in land that could be protected, and a way to do that in unregistered land. In registered land, we are still dealing with their sole system of registration being through this Act, and using a piece of the Land Registration Act 2002 to do that, but they're appearing in that section of the document. They're appearing in the charges register part of registration. So that kind of symbolism that you keeping the language usage is important. We then have the title plan, which literally is a plan or a map of the property itself, outlining any boundaries and any articulation of people either side, etc., where it is situated. So what I'll do now is I will take you to the Land Registry website, and you can see that some of the information I'm about to provide you with is easily available at Land Registry. So you can go onto the Land Registry website itself, and there'll be a lot of information that you can look up there as to who can view details, what is it that they need, how much is it, blah blah blah. So there's a lot of information there as to what it is that Land Registry do and how you can apply to it. So what we're going to do is look at in a moment these examples. So there's an example on there of what a title register looks like. So what the registration document itself looks like, and what a title plan looks like. And we're going to look at that together in a moment to see how the property breaks down. But it's quite easy for you to there see what Land Registry themselves are saying about what the register does. It articulates the property itself, who owns it, whether there's any lender offsetting a mortgage, how much was paid for it, what the stated value is of it, and any other sort of rights or attachments, restrictions that have been placed upon the property. So all the things that we know over the last couple of weeks matter and will attach and affix to the land should be articulated at Land Registry itself. So if we're thinking about the property register itself, these are the things that will appear in the property area of the register. The date that it was first registered, remember we were looking at the fact that people could have gone out on the 1st of January 1926 and registered the land, but more likely there will have been a trigger event where the land has been sold or mortgaged over the years, and that would act as a trigger to registration. It will describe the estate itself, so it will describe the land, given address, etc. There we go, correct postal address will be documented, and any rights that that property comes with. So does that property itself actually benefit from any rights over others? So here you go, this is a copy, and it shows, as it says, the entries on the register. It's got the title number there, so that will be the reference number that Land Registry have for that piece of land. Again, it's got the date that it was first registered, so there must have been a trigger event in on the 29th of August that led to it having to become registered. And as we see, it articulates the geographical location and the extent. So it usually refers to the address. It refers to the title plan by saying that it's edged in red. It then refers to other benefits, saying that the land tinted yellow has other rights on it. So it has a right of way over other land. So that's a benefit that comes with this piece of land over land. Okay, so we have the benefit there of others over others, and obviously this is fictitious. There's no such thing as coinshare, but it is the example given at Land Registry of what the first aspect of the registration document looks like. So you can see property register, a few sentences, and then down the bottom, end of property register. So that's just the top aspect of the registration document. You got your title number, your address, a reference to the plan, and any other benefits that it comes with. The proprietorship aspect then would have the date of purchase by the current fee simple absolute and possession holder. So not just the trigger for first registration, but when was it bought by the current fee simple absolute and possession owner? Who is that person? Who is then the registered proprietor, the freeholder, the owner, the fee simple absolute and possession holder? All of these phrases for effectively the same person. Any restrictions that would be placed on the sale of that property, and that's very important. We will look at section 43 restrictions together in a moment. So this would be somebody who affects the ability of the true owner to behave completely, absolutely without any barrier or any hold. So if there is a bank or if there's a beneficiary who has some form of hold over the land themselves and could be considered a partial owner in some way, they could enter a restriction upon the proprietor's ability to freely sell the land. And that's really important. That's something we'll come back to again next week a few times. And any personal covenants, so anything that is restricting the proprietor, so anything that is personally covenanted by that owner to prevent them doing certain things with the land. Also, obviously, then stating how much was paid for it. So, proprietorship part of the register looks like this. You've got the date there that that person or those people have become the registered proprietors. You have that price element that we've just said, so that what was the purchase price paid on that date. And we've got the bank there. So the bank have entered a restriction. This is the bank's ability to put themselves on the register next to the true owner. That's how important their hold is over the land. So that's the ability for the bank to put themselves in one part of the register, and as we'll see in a moment, they have the ability to put themselves somewhere else as well. They are the only party who can put themselves on the register in two places. So that shows the extent to which they have a hold over the land. So you will see the owners, you will see the date it was purchased, you will see the price, and you will see the restriction on sale. This, as it says, specifies the quality of the title, gives the name and address, whether there are any restrictions on their power to sell, mortgage, or otherwise deal with the land. It may give details of price paid or value information relating to the title. It usually does, to be honest. So we've looked at the property aspect of the register. This is the proprietorship or the ownership part of the register, and you can see up there in the corner we have an absolute freehold. So that is the type of title that we're looking at. That's the form of estate that would be being transferred and registered at Land Registry. Then finally we have the charges aspect. So we have that ability for people to register formal charges, what we would recognise as a charge and we've discussed as a mortgage. So that ability for the bank again to protect their interest by registering it as a charge on that part of the registration document and what date they entered into that agreement with the freeholder. But it also is an opportunity for other parties to place a charge onto the register and articulate and identify some hold that they may have over the land as well. And again, that's something we will look at together when we're articulating provisions of the legislation as to how people would enter themselves at Land Registry. Fairly obviously, they aren't going to appear on the property register because that just says what the property is. Again, fairly obviously, they're not going to appear on the proprietorship aspect unless they're a bank or a beneficiary. So the charges register is kind of where everyone else has to go. It's where everything else states how these people have a right that attaches and affixes to land. So there we will see the conveyance is restricted by covenants. So we have somebody who has put covenants on there. So we have a covenant that the vendor is conveying it so that the purchaser and his successors in title, so anyone else who comes along afterwards, will not use the premises for the retail sale of grocery or as a butcher's shop. So we have a very specific, very binding and very long lasting covenant attached to that property. We then have it also subject to a previous conveyance in 1968, reserving rights for the council to enter land to construct a sewer, and again with reference to where that might be on a plan. Again, another one regarding a restrictive covenant, but here we have a note stating that it's too lengthy to actually put into this document like the covenant above. Oh, sorry, I'm so bunged up. But that there will be a copy of that covenant on file somewhere. We have the registered charge. So again, we have this way for the bank to protect themselves. So we have a mortgage taken on the property, the interest in the property being the mortgage going to the bank on the 3rd of December 2001 in order to provide monies for the purchase price. So there we go, a registered mortgage, a charge affecting the title, gives the date and the name and address of the lender. And that stipulates there this fact that there's going to be some formal document elsewhere that is attaching to this agreement here. So that says the charges register contains identifying particulars of registered mortgages and notice of any other financial burdens secured on the property. Doesn't usually disclose details of money involved, and it also gives notice of other rights and interests to which the property is subject, such as leases, rights of way, or covenants restricting the use of the property. So hopefully now you've seen enough and heard enough land law language to realise that primarily we are dealing with this aspect of the registration document. The people that we've looked at so far as having rights that attach and affix to land apart from the true owner are primarily going to be down here. As we said, we looked at the bank and the beneficiary's right to put a restriction on, and we will cover that in a lot of detail, but the majority of people that we're looking at will be down here in the Charges Register. Then an example of the title plan itself. So that's quite a broad one. There is usually then a more specific, smaller one that articulates within that boundary. So we saw a moment ago they were referring to the yellow line and the blue line and the dotted line. There probably would be, in addition to this more general Ordnance Survey boundary line and local properties, there would probably be something more specific that relates to some of those rights and interests that were being referenced a moment ago in the charges aspect of the register. So that is what a registration looks like. That's what appears at Land Registry. That's what we as land lawyers will go to Land Registry looking for. So the next phase then for us is to start to understand how we can attach and affix to the land. Who are these people and how do they show the world at large that that's what they have? And it's broken down into sections and also schedules. We're mostly dealing with sections today, and then next week we'll look at the schedules of the Land Registration Act 2002. So again, what I would advise you do during this, I would advise you also have access to that 4-box document that we looked at previously, just for your own ease of being able to map across from estate through to law and equity, through to piece of paper, and now where we're at the moment, thinking about how to register them. So if you've got access to that, that would be really helpful, because that's ultimately where we're headed next week, of just using that document a lot and looking at people who are on land and tracking them across. So the first one we see there under Section 27 of the Land Registration Act 2002 would be people who have what's known as registrable dispositions. So these are people who absolutely have to protect themselves at Land Registry, and if they fail to do so, their right does not exist. So we have to have these people protected, and it has to appear at Land Registry. And under Section 27, that's their right and burden, really, as a registrable disposition holder. So any transfer or sale of land has to be attached and affixed to the land. We know it's going to be the fee simple absolute in possession. We know it's a legal estate. We know it needs a deed. And now we're further recognising how important it is in the eyes of the law by saying that this person then has to put it under a registrable disposition. Section 27 of the Land Registration Act says that that's what they have got to do. So that's their burden, really, as the true owner of land. In order to protect themselves, they have to put it at Land Registry under Section 27. A legal lease for 7 years plus. So again, we looked at the fact that a lease was capable of being legal estate under Section 11B, a term of years absolute. In order to be legal, it should have a deed, except if it's under 3 years. But if it's over 7 years, it has to appear at Land Registry under Section 27. That person has to protect themselves and go to Land Registry and tell the world at large that that's what they have. A legal lease beginning 3 months after grant would be akin to a student let. For example, if you went to see a property in June, May or June, and then you weren't going to take the property on until September or October, you might have signed a binding lease, but there would be no evidence of you. You would have no protection if somebody came along to buy. You would not be a sitting tenant because you're not actually physically there yet. So your way of protecting yourself, your only way of protecting yourself if that property was sold in the interim, would be to go to land registry and tell the world at large that you exist. Again, knowing that under Section 27 you actually have to. So if you haven't, you have no protection mechanism whatsoever. You don't exist. So any of those leases that start 3 months after they've been formalised, but occupation doesn't take place for 3 months in the future or more, they have to appear at land registry in order to be protected. Now, I'm sure if you've ever signed an agreement like that, you probably didn't go to land registry. The point being then, if that property had sold and you wanted to take possession, your right wouldn't have existed. Whereas if you'd gone to land registry and told the world at large that you existed, then you would have been evidenced whenever that property was being sold. So that's something we can discuss in class if you'd like to. The express grant or reservation of a legal easement. Now, some of that language usage isn't particularly helpful at the moment because we haven't covered easements, and we will look at that in more detail when we do, but you should now know what a legal easement is. So a legal easement is one of those Section 1(2)(a) easements that looks like it's freely given or it's for a fixed period of time. It was capable of being legal, therefore, in order to become legal, it needed a deed under Section 52 of the LPA. And now, in order for that person to protect themselves in the eyes of the world at large, they have to register it. They have to, under Section 27 of the Land Registration Act, go to land registry and put it down so that they can be seen and a new purchaser or a lender knows of their interest. And finally, the grant of a legal charge, which we know as a mortgage. A rent charge we haven't covered because it's very old-fashioned and hardly ever happens, but it is a way of securing money against land as a landlord rather than as a bank. But we don't need to deal with it in this module. So any bank who have a legal mortgage or a second mortgage against a property will need to register that at land registry for the world to see. So that'll be a registrable disposition under Section 27, and the purchaser is subjected to them. They have to appear. As you can see in the final sentence of this slide, other than the transfer of the fee simple absolute in possession, which would put that person up on the proprietorship register, all of these other parties down here, including the bank, would appear in the charges aspect of the register. So like I said, that final bit of the document, the most important part for us in articulating who has a hold over the land. Okay, so these are the people who have to register their position. They have to state that they have got this hold on the land and enter it at registry in order for it to even exist and be recognised. So just take a moment and look through that list. You have a fee simple absolute in possession holder, legal estate. You have term of years absolute, legal estate. So the two forms of legal estate are registrable dispositions under Section 27. You have a future legal lease, which is still legal estate. You have a legal easement, which is a legal interest, and two of the other forms of legal interests. So 4 out of 5, because you've got any legal charge there. So 4 out of 5 of your legal interests are also registrable dispositions. The only one that doesn't appear there is a landlord's right of entry. So if you're mapping across, if you're using that 4-box approach, you should be able to see that pretty much all of your legal estates and interests, bar landlord's right of entry and a lease under 7 years, will become registrable dispositions. They have to appear at registry, and that is because they're legal. They're so important and they're so binding, and they should have such a strong evidentiary requirement like a deed, that then obviously they should be protected in the highest way possible at land registry. So in my mind that makes sense. We can quite easily map across legal estates and interests pretty much exclusively then into that section 27 category. So if we're thinking about fee simple, absolute and possession holder as a legal estate, that person should definitely appear as the new proprietor under section 27 of the Land Registration Act 2002. Our tenant, which was a 10-year tenancy if we recall correctly, would also be a legal estate holder under section 11B, need a deed, and also be section 27 Land Registration Act 2002 registrable disposition. Beneficial interest we don't need to deal with at the moment, doesn't appear in section 27. The legal easement with a deed again could be a section 27, because we have legal easements that are expressly granted or reserved, and we'll look at what that means when we get to easements. Restrictive covenant is only equitable, so we know it's not going to be in section 27. The mortgage we know is a legal interest, and any charge, any mortgage, first mortgage, second mortgage, third mortgage, will have to be registered under section 27. Landlord's right of entry is the only legal interest that we articulated is not listed in section 27. Okay, so it's possible to look at that, the exercise that we've already done, and use it for everything so far. You can use it for your estates and interests, you can use it for law and equity, you can use it for paperwork which isn't actually in here, and now you can start to use it for registered title as well. How do these people appear at land registry? And that's where we're headed next. Those are the exercises we're about to do together. Next would be minor interests. So these are people who have an interest in the land. It's obviously not as burdensome as the legal charge, for example, or the legal easement, or those ones that are higher, the heightened ones. So these are ways where people could enter an interest, and we will look at that together in more detail mostly next week. So the people who could enter a minor notice are, so with leases obviously you should be able to identify that we have got nothing so far for leases under 7 years. So if somebody has a lease that is between 3 and 7 years, they could enter a minor interest. Easements and restrictive covenants, we'll come to what the exceptions for that would be at a later stage, but we've got easements and restrictive covenants that could be entered as minor interests under the sections 32 and 39. So these are ways that people can put those promissory elements, those more equitable elements, and also estate contracts, the promises between two parties. There is also a way for the person who is cohabiting to put themselves on at land registry, but they have to be married or in a civil partnership of some form. So the spouse's right to occupy the matrimonial home is capable of being entered as a notice at land registry. So that person can tell the world at large that they exist, but not because they're a beneficiary, because they have married. Then the last one, which I find very difficult to make sense of, because we've got these ones that could have been entered at should have been entered at land registry under section 27 and haven't been, and then this person could enter a notice instead. But that doesn't really make a great deal of sense if you're thinking that this person should have been at land registry under section 27 and didn't, so now instead they're going to use a notice. So that's a kind of administrative situation where somebody is waiting on some form of proof of identity or some sort of evidentiary requirement that they are the true party needed to evidence, or the right document, for example the deed needed to evidence that legal estate or interest. Then in the interim what they can do is they can enter a notice, because that is a shorter, quicker way for them to say to the world at large that they do exist. They're just waiting on a formality in order to have that thing that they need to evidence that they have legal estate or legal interest. Usually is a matter of waiting for the deed to happen. So those minor interests, I think the example is going to come up, but I don't need the example to come up just yet, because what we do need to look at before we consider the examples would be look at the exceptions to when you can enter a notice under section 33. So notices are predominantly dealt with in sections 32, but then the administrative aspect of them ranges from 32 to 39. Section 33 says when we can't have a notice entered, and we will look at that together. So I just want to click through this because I don't want to do the examples until we look at the exceptions. So thinking about when a person could enter a notice versus when a person can't enter a notice, these are the things that cannot be protected by entry of a notice. So an interest under a trust. So like I said, they have to be married. It cannot just be a beneficial interest under a trust, because that person cannot enter a notice. They can enter something else, but they cannot enter a notice. The other party that we're mostly concerned with, so I've only highlighted the two that I want us to focus on, because the rest are very aren't really events for us. The other would be a short-term lease. So a lease under 3 years can never be entered as a notice. It can't appear anywhere at land registry. So remember when we thought about the crack in the mirror and where this person can't appear at land registry, how do we then as a new purchaser know about them? So if it's under 7 years, they can't enter a registrable disposition. If it's under 3 years, they can't enter a notice. So the short-term lease, the protection really only is through their possession, their occupation. They would have to be there and be evidenced. So we'll look at that in more detail together. Okay, so back to these estates and interests. We've already looked at the fact that Ali and Brenda have legal estate with a deed that then would be section 27 because of the nature of Brenda's 10-year lease. If that lease was not 10 years, if that lease was below 7 years, so if that was a 5-year lease, then Brenda could enter a notice under section 32. However, if Brenda's lease was lower than 3 years, she could not enter a notice at all. She'd have no way of putting herself on the register for the world to see that she exists. So leases is an area that we will need to look at together, because you've got these disparate timelines of 7 and 3, etc. to look at. And hopefully if you can map across using your 4-box approach, you'll see that it's something I've dealt with in those boxes. Yvonne has a beneficial interest. We know it can only be equitable. We know it can't be protected by a deed. It would need to be in writing, but that's unlikely. So we might not need writing. Section 53(1)(b). But then we're thinking about how she protects herself at land registry. And she can't enter a Section 27 because she's not got legal estate or interest. She can't actually enter a notice because she's not a spouse. She doesn't have the right to occupy the matrimonial home. And Section 33 says that she can't enter a notice under the exceptions. So far, we are very limited as to how we can help Yvonne. We'll have to try something else in order to help her. Karen's easement we've already dealt with. If it's legal, then we will have a situation where that legal easement can be protected and has to be protected under Section 27. If it's equitable, however, we could be able to protect it through notice under Section 32. Restrictive covenant can only be equitable and should be protected through a notice under Section 32. The bank's mortgage remains legal, needs a deed, and is Section 27. However, the bank also have a number of other ways of putting themselves on, and we'll look at that when we're headed into restrictions next. Ali's landlord's right of entry. So this would be a place that she could put a charge down. Her landlord's right of entry would be capable of being protected as a notice. That would be something that she could put down and protect herself with. So the final aspect, I know this is tricksy stuff to get your head around, and it's stuff that we will be dealing with together. The final way, we've already established, we found one person who has no way at all of putting themselves on the register, Yvonne, who's invested in the property. The final way that somebody can put themselves on the register is through a restriction, usually under Section 43 of the Land Registration Act 2002. It's dealt with across sections 40 to 47. So this prevents any dealing with the land that would be inconsistent with the terms of the wording of the restriction. So I need you to remember where we were at the start of this lecture. We need you to remember that we looked at the property aspect of the register, which just mentioned the address of the place and what it looked like. We then looked at the proprietorship register, and we articulated and identified that the bank could put themselves up next to the true owner. This is how they did that. Their Section 27 registration of their mortgage appears down in the charges area. Their restriction of the true owner appears up in the proprietorship aspect of the register. So the bank, by putting themselves up there, articulate that they have restricted, fettered, burdened the true owner, and that it's impossible for the land to pass on without paying the bank off or without freeing the land of the bank's hold. Okay, so it will prevent any further registration of the land. The land will not be able to be registered by anyone else unless that person is satisfied. So that could be repayment of total mortgage debt. It could be the consent of a beneficiary. So here we have an ability for somebody who has the power to fetter the true owner. Not just a bank, but could be a beneficial interest under a trust. And that could be the only way someone like Yvonne could restrict the true owner's hold over the land and wave a flag some way, telling us, the world at large, that they exist. Again, the likelihood of someone like Yvonne knowing that that's how they have to behave is minimal, and that's where we as landlords have to step in and ensure. We need to ensure that someone like that, if we're protecting them, knows that that's how they behave. They put a restriction into land registry that completely handcuffs the true owner's ability to pass the land on without involving them in some way. Or if we're advising a purchaser who's coming along and sees that they exist, we need to advise our purchaser as to how we take them out, how we deal with them. And that's called overreaching. That's the payment of property monies to more than two trustees or two or more trustees. And that's the way that we would take that person out in advising a new purchaser. That's where we're headed next. Okay, so we're going to look at these little loopholes. We're going to look at what do we do about tenants, what do we do about people who are cohabiting, where they're not married, etc. How do they protect themselves, and how do we then deal with that protection? Because even with their protection, there may be some mechanism for us to still transfer past the land, take the land. So please don't worry or stress about those last few slides when we're looking at registrable dispositions, notices, exceptions to notices, and then restrictions. It's something we're going to do together an awful lot. For now, just bear in mind that we already articulated that Ali and Brenda, in our scenario that we were given, would have registrable dispositions. They would have to appear at land registry as those people for the world at large to see. Yvonne's going to be more complicated, and that's where we're headed. To be honest, we're looking at people like Yvonne who can't easily access entry on the register, probably don't know that they need to be on the register, and how we deal with that. So they can only have an equitable interest. It's probably not going to be in writing, and it's probably not going to be at land registry. So those are the people that are that crack in the mirror that we talked about in the mirror principle, and we'll investigate that in more detail together. Again, Karen's easement could be tricksy for us. We're going to look at legal easements, equitable easements, writing, contract, deed, implying them. Whenever we come to easements, we can play. But ultimately, at this stage, what I need you to know and appreciate about easements would be a legal easement has to be protected under Section 27. An equitable easement can be protected under Notice Section 32. Restrictive covenants, only ever equitable, only ever contractual, and should appear under a Section 32 notice. Bank's mortgage is a registrable disposition. They have to enter it under Section 27. Then the bank also could restrict the true owner's ability to pass the property on and put in a restriction to under Section 43 of the Land Registration Act. And finally, Ali's landlord's right of entry is capable of being a minor interest under Section 32. Okay, so I know there's a lot this week to get your head around. I know that we'll spend time together breaking it down a number of different ways. Ultimately, what I need you to know is that why we looked at that breakdown of the register was so that you can start to see what this looks like in terms of appearing to the world at large, the aspects of attributes of the property itself, who we recognise as the true owner, and whether they're fettered in some way by another party. And then this kind of charges element of lots of people saying that they have a right or some sort of hold over the land and how they protect themselves, usually through Section 27, Section 32. Thank you very much for your attention. Sorry I'm so blocked up.